All right, well, keeping going with the flow of deontic norms, I'm going to be talking about the problem of customary law for legal ontologies, exploring primate normativity to codified law. So the motivation of this paper stems from a paper that Dr. Smith and Dr. Zapert wrote that discusses that there appears to be three different types of normativity, and legal ontologies and social ontologies need to be able to deal with these three different types of normativity. So the first example would be kind of what Brian had just spoke about. We seem to have these logically grounded normativity that come from constitutive rules. So I make a promise, I make an utterance and a promise, and with that comes this claim and obligation that follows. We can think of like HLA Hart and like positivism here. So like contracts, the UCC, Uniform Commercial Code. This seems to be the first set of normativity that we have. There seems to then be a second set of second type of normativity, which typically has been reserved for the discussion between legal positivism and natural law theory. And so this would be the I ought to respect my parents. I ought to, if I have a parent, care for my child. I ought to not kill. And so these seem to exist before any written or speech act or any of these sort of social acts occur. And I want to argue that legal ontologies need to find a place for these. And the third one would just be also normativity that's rooted in logically grounded, but it contains this like mental phenomena, which would be, it seems to be, if I do the right thing intentionally, that's better than doing it by accident. But the focus of this paper and topic will be on the second type of normativity, which I will define as customary norms and customary laws. So once again, this is the motivation for the paper. So before going any further, it's important to understand kind of what I had just discussed a little bit, what legal ontologies are currently able to find a place for. I will argue that there are certain deontic norms that they can account for. Once again, any like written act that would produce a contract. Once again, any like promises I make. These deontic norms we can find that are produced by any utterances of promises that I make from language and social acts seem to be able to be legal ontologies can find a place for. What I will argue that legal ontologies have not been able to find a place for are these customary norms, which again is the second type of normativity that Dr. Smith wrote about in his paper. So this is how I've defined a deontic norm. So their creation cannot be accounted for by speech and document act theories. So once again, it appears that I have some obligation not to kill someone, or I have an obligation to, if I'm a mother, like care for my child, or I should respect my parents, regardless of if this is spoken, if I make any promises, whether this is like codified in some law. And so once again, the debate typically for this has just been between legal positivism and customary law, or excuse me, legal positivism and natural law theory. And I want to avoid having to go into either of those. So natural law theory would say, hey, it's just like inherent because I'm a human. And so these could like give rise to like brute facts, like just because I'm a Homo sapien, I have these inherent like obligations. And so that might not be very satisfactory. And legal positivism would say, well, I shouldn't kill because like man made this law. But that's not maybe satisfactory because like I'm going to try to motivate here. It seems to be that we have this obligation before man made any law. So that's why I don't really find natural law, or in this case, legal positivism satisfactory. So we're going to try to take a different approach with this. And what I'm going to try to argue is customary norm needs to be found a place for in legal ontology, as well as customary law. So customary norms are going to be what develop these customary laws in Homo sapiens and societies. And so we just have a law as a system of rules that identify what is legal and illegal behavior. So legal would be what is permitted by the law. Illegal would be what is forbidden by the law. And so I want to argue that legal ontologies are able to capture certainly some aspects of law. So whether that be like legal positivism or different like contracts or promises or any like statutory law or like common law here or judicial precedent. But then there seems to be this like customary law that they have not been able to find a place for, and I'm going to argue that it's really important that we do so. So the trajectory or the focus of the paper, once again, is legal ontologies need to find a place for customary norms and the associated groups of customary laws that they produce. And so if I'm going to argue this, we need to be able to motivate where these, I need to motivate to you all where these customary laws and customary norms arose from, how they came into being, why they exist in reality. So there's 4 steps to this. So the trajectory of the paper will look at customary norms and ancestral primates. So we're going to see like, hey, did our ancestors like have these norms? Is it more than just they're gratuitous, or they recognize they are nice to people or nice to other primates when they are like helping them, or is there an actual like an ought in normate primitivity? Then we're going to look at customary laws in primitive tribes. So I'm going to argue that these customary norms that we find in primates are what produce these like customary laws in primitive tribes. But it's really important to note here that these customary laws are very limited in the sense that language is not yet developed. The 2 main things are going to be language and punishment. And in here we're going to see it's expanded upon greatly customary laws and social cooperation and the flourishing of humans when we have these institutions that arise and when we have language in primitive tribes. And then the 4th series to see how norms and laws have evolved over time is we're going to look at codified law real quick. So for step 1, customary norms in primates, I'm going to try to motivate that we do see that there is normativity and oughts in the primitive and primate in our primate ancestors. So when you look at, this is an interesting study. Instead of looking at just the chimpanzee's reaction when someone harmed or another primate harms them, they actually look at the bystanders in the group to try to see if this action possibly upset all the primates, to try to recognize that there is some sort of like normativity going on here because everyone is affected if this is a deviation from like some social norm. So we have in primates this impartial policing that is going on. So they have these like high-ranking male chimpanzees that impartially try to fix any like aggression that may be arising. For controlling escalating male violence, they have these like female coalitions that try to like come on in and break up when males are trying to compete with like which one is stronger. And I think personally I find most persuasive the tolerance towards infants. So we see, I think this is probably the strongest case to show that there are these like universalizable customary norms in primates. So like time after time, there's a whole bunch of studies which show mother chimpanzees living in like with certain other chimpanzees for years and years and years and has working relationships with them, and then one tries to come way too close to her baby, and the lesson is like, you don't go and hurt mama's baby, and she reacts very, very harshly, and there seems to be a very innate sort of tolerance towards infants that's understood in other infants because they can see how adults act. So it is universally known that you just don't mess with babies. Also very interesting, like I said, I'm going to argue that part of this evolution of laws and norms is really going to be focusing on language, which we'll get to later, but also punishment and sanctioning. So we can see like the roots of it here. So in this is a really interesting study. These capuchin monkeys, they are like very keen on equal distribution. There are a bunch of different studies where they have 2 monkeys and one will get grapes, which are preferable over like cucumbers. And if they both get grapes, they'll both eat. But if one gets a grape and one gets a cucumber, the other one like refuses to eat. In the same sense, there was one study where one of the monkeys was able to get food if they pulled a lever, but it recognized that by pulling the lever, another monkey would not be able to eat and would actually get like a shock. And this monkey for like 5 days wouldn't eat. And we see here within a group, if there's actually, whether it's intentional or not, any disruption in this like fair and equal distribution of resources, we see this notion of punishment occurring. And until that is replaced and there is resources and sharing put back in place, it's very evident that there seems to be like a sanctioning that's happening when the ideal is not met and the punishment is put in place until we have equal distribution again. We have the example of a baboon, which if there's like a male that comes and tries to once again get too close to a baby, there's like mobbing that goes on. It's like pretty intense until the male steps away from the baby. And then so once again, when there's deviation from the ideal, which would be in this case like hierarchy of like ranking and fair distribution, there's punishment to correct the behavior. So here what I'm trying to motivate in step 1 is show that there is customary norms in primates. And so this is what's going to help us get to step 2, which is we have customary law and primitive tribes. I think what's super important here is this is key because natural law theory, possible argument against it would be you just want to say that I have these obligations inherent to being a human. This is like a brute fact. There's no explanation for it. So by showing that we have roots in these customary norms in ancestral primates, we can evolve the argument that these are just like brute facts that we have. And I'll argue that customary norms in primates developed this customary law. And so to show this, we'll look at the Yanomamo tribe in the Amazon rainforest. And these are the 3 areas that are really important to focus on that are going to be in distinction with step 3. So we have these customary norms. They developed into customary laws in primitive, ancestral tribes. The language here, I know it's helpful to give examples, but it tends to be shrieking, so I'm going to refrain from giving shrieking examples, but their language is very limited in that sense, so we just had shrieking and maybe different noises and grunts. Once again, I know examples are helpful in presentations, but I'm not going to do that. So we have this language here that's very limited. We do not have any examples of committees or elders. There's just alpha males, so I'm going to try to be the strongest in this tribe that I'm in. These are who the women are attracted to, so this produces making sure that there will be a continuing development of offspring, because this is who the women will mate with in order to continue the community. And what's also very noticeable is punishment here. So the punishment is not going to be because there's a deviation of a norm. It just would be punishment that if I'm an alpha male and you've offended me because you're trying to threaten my alpha male, then I'm gonna punish you if I feel threatened. So it's not a deviation that we're getting into. We can see the roots of punishment still continuing. It's thread through all of this, but it's going to be in sharp distinction to step 3. So once again, we see language, which would just be shrieking and different noises. We don't have any institutional arrangements, and then we have punishment. But most importantly to notice is that these customary norms have developed into customary laws and just customary law in primitive tribes. And then we're going to get to more examples of tribes, but this is going to be customary law plus something else that's coming into existence here. And I'm going to argue what allows this to come into existence is language, so that would be agreeable with Searle, and also with punishment. This is going to, I'm going to agree with Robert Boyd that punishment and sanctioning is what allows for this human flourishing. If we don't have it, we're going to go back to the Yanomamo. So with step 3, customary law plus more in tribes, here I'm going to argue that in addition to these customary norms that we see, we have institutional arrangements. So this is going to be chiefs or elders or committees, and the language is going to be very distinct from step 2, which is just these shrieks. Once again, this would be actual language. So I would try to motivate and argue that this is where social acts and speech acts came into existence, where I'm now able to make promises and these utterances that give rise to these claims and obligations. So we can look at the Troprianders in Papua New Guinea, who are very interesting to study because there's a lot of research on the effects of colonization with the Troprianders and how they're dealing with customary law and these different threatening behaviors towards it. So we have customary law plus more, and once again in tribes. So here, once again, I'm going to argue that we have language, which is going to be the main component that allows for this human flourishing and for this rise of social cooperation. Here we have speech acts coming in to evolve. We have committees and elders, so there's a chief elder that is able to handle disputes through the different villages. And then also very key to this is punishment. And once again, they have actual understandings of punishment. So if I kill a chief, I'm going to die. And so that's universally recognized in the tribe. Noticeably different than I'm just going to punish you because you threatened me. And it's just more of killing, which is what we saw in the Yanomamo. So step 4, which is kind of what we are going to be getting to, is codified law. So here we have document and speech acts. This is what positive law can come into effect at this point. This is where we can finally see human flourishing I'm also going to argue because of punishment. So I will agree with Robert Boyd that what allows for, once we have language, but what allows us to then get to even more, and we saw the root of this in step 3, what allows us to get even further to a stable society is this fear of punishment. We need to recognize that there are defectors in society, so we're all going to follow the norms, but someone is going to bank on the fact that I lose my wallet and my keys like 4 times a day, and so they're going to try to like steal that. And so what keeps everyone from not just being a defector, and why do we see that there's a benefit to cooperate? I'm going to argue that that's widespread punishment, and so I recognize that I could be punished if I defect. There's an advantage if I recognize we all cooperate, and so this stable society and this punishment of defectors is why we don't collapse back into step 2 for the anonimo. And then I'm just going to once again argue that instead of being able to have to instead of being able to have to say that this obligation to respect my parents or treat and care for children came from either positive law, which is just man-made, or natural law theory is just inherent to humans. I tried to show that we have these customary norms that have came into existence with our ancestral primates. Humans greatly expanded on them, and tribes to give us this customary law. When we had language and punishment, this really like expanded it, and this allowed for this like social cooperation that we currently live in. And so the main argument is that legal ontologies need to find a place for customary norms and this associated customary law that they produce. I recognize that positive law has codified a lot of these. If we look at like the Uniform Commercial Code, or we look at like murder and like homicide, but I do not think that they created these customary laws. Like I said, I think that these originated from customary norms in our ancestors. So my hope is that this gets away from the common discussion of legal positivism and natural law theory, and this is a different way to be able to account for those customary norms.
So I want to talk to you more about ontology of law, because this is a big and growing field, and I'm interested in it. So I think there's a story that you want to tell, an evolutionary story about how these customary norms came to develop. But there are ways that Barry's been trying to lay out some scaffolding for how to do that. So we're trying. There are some things that I'm not sure what you mean.
Sure.
So, for instance, I don't know what a customary law is. And then I also wanted to scare you a little bit about some of the ways in which you were drawing your argument.
Sure.
So the Yanomamo.
Yes.
They had a book written about them by an ethnographer named Napoleon Chagnon, who you might be pulling from, and he really had a philosophical axe to grind. And so he came in and said, Rousseau's noble people in the forest, they're evil, they're awful, they beat their wives and they're horrible. And it made a big splash on the community of anthropologists. But since then, lots of people have gone back and they've done ethnographies of the Yanomamo, and they kind of hated this guy and they didn't like him, and he didn't really do a good job of characterizing their tribe, and so he's been really criticized. Even though I still see the philosophical community constantly pick up his work.
I think that there's been another iteration. People went back and tested the results of the people who criticized Danielle. Now he is once more, it seems,
vindicated. Okay, so I've been overruled. But in any case, anyway, it bears some checking.
I appreciate that.
I think there might be other sources of information you could look to for your general thesis, like Steven Pinker's new book, where he argues that rates of violence drop when civilization grows. I think that would be a better way of doing it, rather than beating up on the poor Yanomamo again.
Okay.
So that might be a place to look. But could you say what you take the difference between customary norms and customary laws to be?
Right, so I want to say that customary norms are what we see in primates, and so the example would be like caring for an infant, and so these are norms that society recognizes are how I ought to behave, and I want to try to argue that humans expanded on this, and these are what created customary law by this like evolution process. That's what the root is customary norms, then are what create customary laws. So customary laws would be how this society recognizes they ought to behave, but it can occur before there are like written documents and before there are speech acts.
Well, why doesn't the society then have customary norms?
I would argue that they also do have customary norms as well within the society, but I would argue that customary law would be distinct to Homo sapiens, and I can't apply that back to primates. But I do think that there are customary norms within.
But these laws aren't written down, right?
Correct, and that would be distinguished from.
I don't see how that's distinguished from norms, then.
Okay,
because norms aren't written down either. So.
Yeah, so I think maybe, and that's very helpful, I think when I define law here, I think a customary norm would just be, so it's sort of like deontic norm that brings like an obligation, and that might not necessarily be what is legal or illegal behavior. So what is permitted by the law and what is forbidden. So it might be like frowned upon, I think, but I would argue that customary laws are a little bit stronger than a customary norm. Customary norm might not be frowned upon, but I don't think, it may be frowned upon, but I don't think it warrants the sort of punishment involved with law. I think it's the root of it, but I think when it becomes customary law, I think we then go into this idea of what is permitted and what is forbidden, whether that's written down. So customary law wouldn't be written down, but there seems to be this notion of punishment that's stronger than just a customary norm.
Okay.
That I
so
appreciate.
It's one of strength is what you
I think so, yeah. Right?
So I take it you really dislike natural law theory. That's the vibe I'm getting, right?
No, I don't strongly dislike it, but I think it's helpful to have another way to approach this question, because it seems to be this debate just back and forth between legal positivism and natural law theory, and I think that this is a helpful way to be able to explain as well.
Okay, so you would want natural law theory as part of the legal ontology as well, or?
I think that there are positive aspects to it, but I would not include it in the legal ontology.
Okay, so
there are parts I should rephrase it. There are parts that I find attractive, but I don't think it's strong enough to warrant to be part of a legal ontology.
Sure. So this would supplant that then.
Correct. Yep.
So. Can I ask a follow-up?
Go ahead.
Oh, yeah, sorry.
So, in that case, natural law theory kind of made its comeback on things like the Nuremberg trials.
Yep.
Cases where just like this.
Law above the law.
Yes,
Yep.
so obviously wrong that these people do this or whatever, yet the society's flourishing, for lack of a better word. It seems to be extraordinarily efficient, Nazi Germany. Do you think that this sense of, your sense of norms here could possibly, or customary law norms, could supplant natural law theory in being able to deal with a case like Nazi Germany?
Yeah, that's really good. I appreciate that. Right. I think Nuremberg trials especially is why I find aspects of natural law to be persuasive, in the sense that like the chief prosecutor in that case was like, we're going to adhere to the law above the law in this case in order to prosecute, because even though this might have been acceptable within the society, we recognize there's something else going on that's not acceptable. So I could take it that I do think that this is able to produce that force. I don't think maybe in the earliest parts, like when we see customary law or this develop immediately in like a primitive society culture, I would argue that it's probably maybe is not that strong then, but with the development of language and the social cooperation, that it's more widespread than the society specifically to Germany, that maybe it can provide more of like a universal, not universal, but can be applied to humanity in a larger sense than what is accounted for.
So I would just like to add one dimension. I'll set up the next set of slides. So Boyd is a geneticist, and I think that he was implying that there are two stages of development to be distinguished. There's first of all the biological stage of development, and then at some point we reach a stage of development where there is also culture. But culture is a development stage which involves people imitating other people. So it involves learning, it involves imitating prestigious people. And once you get into this culture stage, you immediately have an explosion of possibilities. So people like to imitate prestigious people.